When starting a new business, it's essential to consider which form you want to utilize as a vehicle to run the business from. It's not only important from a general taxation point of view, but also essential from a risk point of view. A sole proprietorship is a business that is operated and owned by a natural person. It therefore has no legal persona, but is one of the simplest forms of business to establish. It can trade under the name of the owner, or it could trade under a fictitious name, bearing in mind that if it trades under a fictitious name, it still doesn't create a separate juristic entity. Therefore, all of the risk and benefit in a sole proprietorship attaches to the actual natural person who owns the business, which also leads to one of the major drawbacks of a sole proprietorship, in that all of the assets of the natural person is attachable for the debt of the business, irrespective of whether they're utilized in the business. The next organizational form we're going to consider is a partnership. A partnership is established when two or more persons come together to operate a business, trade, or profession. It's usually established by concluding a partnership agreement. A partnership also does not have a legal persona. Therefore, each partner is called upon to contribute either money, skills, labor, or knowledge to the partnership. Each partner therefore also has an entitlement to share in either the profit or the losses of the partnership. And here's where one of the major drawbacks of a partnership comes into play. Each partner can be held liable for all of the partnership's debts or liabilities. Therefore, you have joint and several liability as partners. A partnership also has a problem in terms of the continuity of the structure, as every time a partner joins or a partner exists, the partnership technically dissolves. The next form we'll look at are close corporations, or so-called CCs. Since the inception of the New Companies Act, being Act 71 of 2008, new CCs cannot be established. But CCs already in existence can continue to trade. A CC, as opposed to a sole proprietorship and a partnership, does establish a separate legal persona. The owners of a CC would be the members of a CC. They own what's called a membership interest in the CC, and that is expressed as a percentage. The major benefit of a CC is that the members of a CC have limited liability. Therefore, they generally won't be called upon to make good for the debts of the CC. Continuity is also not a problem, as the legal persona exists separately from its members. One of the most generally used formats of business would be a company. A company is treated by law as having a separate legal persona, and therefore it has rights and obligations of its own. The owners of a company would be the shareholders of that company. The company would then be managed and directed by its board of directors. Shareholders of a company would have limited liability, and therefore shareholders would not generally be called upon to make good for the debts of the company. In terms of the Companies Act, however, directors can be held personally liable if they have been found to have breached their fiduciary duties towards the company. Companies also have to be registered by the Companies and Intellectual Property Commission, and therefore the compliance burden on companies is slightly more cumbersome than would be on other formats. Non-profit structures would usually take the form of either a non-profit organization or a non-profit company. These entities are usually established without an objective of making profit. Therefore, they're established with some form of goal or mission statement, usually some form of public benefit activity or social or cultural activity. In the event of a non-profit company, such a company wouldn't have shares or shareholders. It would only have members. Non-profit companies or non-profit organizations then generally also have a number of registrations that they can attend to in order to assist them in achieving their goals or objective. This ranges from NPO organization registrations or certain taxation registrations. When deciding on what organizational form would be best for you, it's not an easy task. There's no one-size-fits-all approach that would work for every business. Therefore, you have to take things into account such as your personal circumstances, your risk appetite, your size and nature of your activities. There's a number of things to think about. We would suggest that you should consult a competent professional in order to discuss the various facets in detail before deciding on a particular form.